Hi, I'm Steve Eveletta, and this is Beans, Beats and Bankruptcy. Today, we're going to be talking about what's hot on the cafe scene, music we're listening to at work, and bankruptcy. So today we're having an espresso pod from Norman Core Coffee Roasters in Sydney CBD. It's up pretty well. In the Beats segment, we're going to be reviewing tracks we work to, how they impact our mood, and whether they assist us to get a good outcome for our clients. So today we're reviewing a pretty well-known and classic Bob Marley track called Three Little Birds. As far as the beats, they're relaxing. It's classic reggae. The reason why I love reggae is it's just a lovely entree into drum and bass, one of my favorite genres of electronic music. As far as the vocals, they're like haunting, as you know, but they're haunting and relaxing and chill at the same time. Workability, strangely, you'd think it'd be a 10, but it's not, like a 7. It's just too catchy. Every time I have the song on, I'm just distracted. So I find it's really useful for, driving in between offices or otherwise doing more monotonous tasks. I just find it too catchy for pleadings and work that requires 110% of my, concentration and focus. And overall comments, it's just an awesome track. Who doesn't love this song? And it sends a pretty good message about mental health and looking after each other as well. So give it a listen. As we progress further and further away from the real basics of bankruptcy, we're really going to start getting into some of the more nuanced mechanics of the Bankruptcy Act and the personal insolvency regime in Australia. That being said, today we're going to be talking about ending bankruptcy and specifically the 3 ways that you can end bankruptcy early. Often people talk about the annulment of a bankruptcy, which is effectively the payment of all debts and the discharge of a bankruptcy. But what people don't know is that there are actually 3 ways that you can exit the bankruptcy process. So, 1. You pay your debts in full, including all your trustees' fees. So that means if they're the official receiver, then you pay APSA. If they're a private trustee, you pay a trustee and all the realisation charges and all your creditors in full. And you contact your trustee and you basically say, hey, I'm ready to go. I'm no longer bankrupt. I've paid all my debts in full. 2, what you do is you go to court. And you go to court, you explain to the court that you should never have been made bankrupt at all, ever. And often that might involve, because of some legal technicality, it might involve the fact that someone stole your identity. It might involve the fact that the whole process has some major technical or natural justice deficiency. But basically, if you think you fall into this category, you need to not only contact your trustee, but a qualified and experienced lawyer and get prepared to have an argument, because this is a complex area of law most of the time. And 3, and most commonly, a composition. And a composition is a scheme by which, pursuant to the Act, you can be discharged from bankruptcy, so you can have your bankruptcy cancelled without paying all of your debts. And what it effectively involves is a level of consultation with yourself, with financial counsellors, if you are very well organised and seeking advice, at least with a lawyer if you need a hand, and with your own bankruptcy trustee to facilitate an offer to your creditors to pay a percentage of your debts. And what it involves is making a formal offer of composition signed and issued to your bankruptcy trustee, making an offer. And when you make that offer, you need to consider all of the potential assets which the bankrupt estate has access to or might have access to as a result of your bankruptcy, and over the 3 years minimum of your income contributions. And then consider what is an offer which creditors might accept, often to put creditors in a position where they're at least as well off as a result of your offer. In doing that, you also need to consider the time value of money, though this is something you should get financial advice around. And of course, the length and expense which a trustee might have to incur in dealing with various transactions as a result of your bankrupt estate, as well as AFSA and other government charges and other expenses and disbursements. And so once you put that offer in, the trustee then has to go about the process of writing a report, analysing your composition arrangement and putting it to creditors in a creditors meeting or otherwise. And as a result of that, creditors then have to vote, and you need a special resolution under the Act which involves a majority of numbers and values. So that means 75% of the value and a majority of creditors need to vote in favour of a composition. And if that happens and you successfully fulfil the terms of the composition that you've proposed, has otherwise been reported on by your trustee and voted in favour of by your creditors, then your bankruptcy ends early in accordance with the terms of your composition. And I guess my general comment in this respect is, if you're considering trying to annul your bankruptcy either by paying all of your debts, so a traditional full annulment, or otherwise through a compromise with your creditors pursuant to a composition under the Bankruptcy Act, get advice straight away as a bankruptcy scenario approaches or after you become bankrupt, because it's important to consider stakeholder relationships and engagement and ensuring that your trustee and your creditors don't incur too many fees in administering your estate, so the viability of a subsequent annulment by full payment or composition is more viable and generally is voted upon in a more pleasant and forthcoming way.